So as you've heard, I am here wearing two hats. I'm here as the leader of the new national movement called Green Amendments for the Generations, but I'm also here as the Delaware Riverkeeper, having worked and served as the leader of the Delaware Riverkeeper network for over 25 years. The reason why it matters for you really to know that I've been working to lead the Delaware Riverkeeper network for all that time is for you to understand that the message that I'm going to deliver today is an outgrowth of my over 25 years of doing environmental advocacy and litigation. It's as a result of the experiences that I've had in that role. And as a result of that work, it has become very, very clear to me that we need a new path for environmental protection here in the United States of America. And whenever I say that, people ask, how can you possibly say that, Maya? If you look at the books, if you look at the local level, the state level, the federal level, we very literally have hundreds of thousands of environmental protection laws here in the United States of America. And as each of these laws has been passed and as each of these laws has been implemented, they all have accomplished a degree of benefit when it comes to communities and our environment. They have reduced pollution and prevented illnesses and supported good economic development based on healthy environments. The problem is they've only been able to accomplish those successes to a certain level, to frankly a predetermined level that's actually captured in the very laws themselves, right? We're only allowed to get that degree of benefit to that preset level written into the laws, into the regulations we have. And as a result, right, of the way these laws are written, these laws are very literally focused more on considering environmental pollution and degradation at the end of the decision-making process, when the focus is on permitting and managing pollution and degradation, not when you can truly be focused on preventing pollution, preventing harm, and preventing degradation. And of course, just in our current system of environmental protection laws, there are a lot of gaps in the laws. There are often political efforts to roll back the laws that we do have on the books. And even to the extent that we have some decent laws on the books, all too often there's poor implementation. So we don't even get the full value of the predetermined level that's actually written into those very same laws. And so as a result, communities across our nation are suffering from pollution and contamination. We have people across the United States of America that are drinking contaminated water, that are living next to highly polluting industrial operations and breathing contaminated air. We have families that are living next to highly contaminated sites. We have communities increasingly suffering the ravages of climate change. Our communities of color, our indigenous communities, our low-income and immigrant communities continue to be unfairly targeted for highly polluting industrial operations and environmentally degrading activities. And of course, it's not just the people that are being harmed by the deficiencies in this current system of environmental protection laws that we have in place. Species, plant and animal species of all kinds, are also being impacted. Their habitats being taken, their very lives being taken. Right? And all of these kinds of things, right? And there are specific stories for each and every one of these elements. But all of these kinds of things are happening despite the fact that we have all of these environmental protection laws in place. And when I go into communities that are suffering from pollution and degradation or facing some major environmental threat of one kind or another, people inevitably have the same question. Why? Why? Why is this happening to us? Why are we suffering in this way in terms of environmental degradation? Why are we facing this new threat to our air, to our water, to our health, to our safety, to our family, to our lives? Don't we as people here on this earth have a right to pure water and clean air, a stable climate, and healthy environments? Aren't these our rights by virtue of the fact that we are people here on this earth? And I have the sad job of telling them no. No. You have all kinds of rights here in the United States of America. You have the right to free speech and freedom of religion. You have due process rights. You have private property rights. You have gun rights. In the state of New York, you have the right to play bingo. But in states across our nation, you do not have a right to a healthy environment, except with very limited exception. Here in the Commonwealth of Pennsylvania, you have a right to all of those fundamental freedoms we hold dear, and you have a constitutional right to pure water, clean air, and a healthy environment. And so people then very quickly ask me, how is it possible that the people of Pennsylvania have these rights when other states, other communities across our nation do not? If you look at Pennsylvania's history, it's just as rich in the overexploitation of the natural resources of the state. The people of Pennsylvania allowed just as much pollution to be spewed into the air and just as much pollution to be spewed into the water. They allowed just as many, boy, you can't see that. They allowed just as many industrial operations to overwhelm Pennsylvania communities as other states across our nation. So what was different about the Commonwealth of Pennsylvania that allowed the people of this state to get a constitutional right to a healthy environment? And what was different was that the people of Pennsylvania had this gentleman. His name is Franklin Curry. Franklin Curry got himself elected to the Pennsylvania legislature in the late 1960s, and he very quickly realized that one of the reasons why Pennsylvania's environment was allowed to become so degraded that it was harming every aspect of the lives of the people of Pennsylvania was because we were not protecting our environmental rights in the same way we were protecting all of those other fundamental rights that we hold dear. And so Franklin Curry decided that he was going to change that, and he proposed that an amendment be added to the Pennsylvania Constitution that would protect the rights of all the people of the state to a healthy environment and recognize the duty of government officials to protect those rights for the benefit of all the people. When this provision went before the House, it passed unanimously. When it went before the Senate, it passed unanimously. And when it went before the people of Pennsylvania in 1971, it passed overwhelmingly by a vote of 4-1. And so in 1971, the people of Pennsylvania literally got a constitutional right to a healthy environment. And so you would have thought from that moment on, environmental protection in the Commonwealth of Pennsylvania would have been so much better than it was for every other state across the nation. But if you know anything about Pennsylvania, and as you are going to hear in greater detail from Professor Dernbach, you will know that that was not to be the story for Pennsylvania's environments and Pennsylvania's communities, because very early on there was a misinterpretation and misapplication of the law that very literally robbed the legal strength of this constitutional right. And I'm going to let Professor Dernbach go into more detail about that. But for long story short, what it meant was that for 42 years we had this great law on the books and in the Constitution, but nothing had really changed for the people of Pennsylvania. Fast forward to the mid-2000s, and here comes drilling and fracking for gas from shale to Pennsylvania communities, bringing with it all of its highly polluting industrial operations, bringing with it the tremendous deforestation, land transformation, and devastation of the natural resources of the Commonwealth of Pennsylvania, bringing with it pollution of the rivers and the streams and the groundwater and even people's drinking water supplies, bringing with it air pollution of all kinds, including climate-changing methane emissions, and bringing with it a proliferation of infrastructure, pipelines and compressor stations, and more. And given the state of the law in the Commonwealth of Pennsylvania, it was really pretty easy for the fracking industry to overwhelm Pennsylvania communities. But for the frackers, they just didn't think it was easy enough. They wanted to find a way to make it even easier for themselves. And so very literally, leaders from the fracking industry got together and went behind closed doors and wrote for themselves a piece of legislation. A piece of legislation that, when it was passed by the Pennsylvania legislature in 2012, came to be known as Act 13. Now, Act 13 did a lot of bad things when it came to fracking. In certain contexts, it gave the fracking industry the power of eminent domain so they could force the storage of their explosive gas under people's properties. It put in place automatic waivers from environmental protection standards. It mandated that communities allow drilling and fracking operations right in the heart of their residential districts, and more. And long story short, because of Act 13, while things were already really bad for the people of Pennsylvania when it came to fracking, because of Act 13, things were about to get a whole lot worse. A whole lot worse. Now, at the Delaware Riverkeeper Network, we have been fighting fracking for many, many years. And in fact, there's no fracking anywhere within the boundaries of the Delaware River watershed, largely because of the work of my organization. But after we achieved the success of protecting the Delaware River from drilling and fracking operations, we didn't sit on our hands and say, whoo, boy, we're safe now, right? We knew that drilling and fracking anywhere in any watershed was harmful to all of us everywhere. And we knew that allowing Act 13 to move forward as it was passed would have been devastating for our environment, for Pennsylvania communities, and for future generations. And so we decided that we were going to challenge Act 13. And we teamed up with 7 towns, and I, in my role as the Delaware Riverkeeper, my organization, the Delaware Riverkeeper Network, and a physician, Dr. Maharnish Khan, decided we were going to challenge Act 13. And we each brought our own arguments to this joint venture. But the argument that the Delaware Riverkeeper Network brought to the table through our attorneys was that the provisions of Act 13 that we were challenging should be declared unconstitutional because they violated the environmental rights of the people of Pennsylvania. The case went all the way up to the Pennsylvania Supreme Court, which at the time was a very conservative Supreme Court. And in December of 2013, we got an amazing victory out of that conservative Pennsylvania Supreme Court. And I want you to read with me a few of the things that Chief Justice Castile wrote in the plurality opinion that came out December of 2013. He wrote that by any responsible account, the exploitation of the Marcellus Shale formation will produce a detrimental effect on the environment, on the people, their children, and future generations. That the natural resources that were going to be harmed were resources essential to life, to health, and to liberty. And that as a result, the provisions of Act 13 that we were challenging were unconstitutional because they violated the environmental rights of the people of Pennsylvania. And in that moment, with that victory, we not only defeated some of the most devastating aspects of Act 13, but we very literally breathed legal life back into that long-ignored Environmental Rights Amendment. Now, since that time, we at the Delaware Riverkeeper Network and other organizations joining in the effort have been doing the work of defining what it actually means to have a constitutional right to a healthy environment and then defending those rights. Because it isn't instantly clear. You don't instantly know where has the line been crossed, where hasn't it been crossed. The highly polluting industrial operations and devastation of landscapes and drinking water supplies, all the bad environmental stuff that was happening in Pennsylvania doesn't instantly disappear, right? We have to go forth and figure out, case by case, context by context, what does it actually mean to have this right? I mean, think about the rights to free speech. Think about gun rights, right? Think about the rights to freedom of religion. We've had those rights for hundreds of years. And yet we still have legal challenges to figure out what they mean in one context or another. Well, we're just at the beginning of that process when it comes to Pennsylvania's Environmental Rights Amendment, Pennsylvania's Green Amendment. We have been doing the work of making sure that every government official at every level of government understands that they have a constitutional obligation to protect the environmental rights of the people of Pennsylvania. And we've been making sure that the people of Pennsylvania understand that they have these rights so they can incorporate them into their environmental protection activities. But as we've been going forth doing this work, very quickly, frankly, I realized that there was something more in this victory than just for the people of Pennsylvania. That there was a message for all communities in all states across our nation. The message that our rights to pure water, clean air, healthy environments, a stable climate, are inalienable, inherent, indefeasible rights that belong to all of us by virtue of the fact that we are people here on this earth. That these are rights that are worthy of constitutional recognition and protection. And that we in communities across the nation must rise up together and demand and defend our environmental rights. And I believe that the best way we can do that is to rise up together and seek and secure the passage of green amendments in every single state across our nation. Green amendments like the Constitutional Environmental Rights Amendment that the Commonwealth of Pennsylvania has. I call it a green amendment movement. We need a green amendment movement. And why do we need a movement? Because there are only 2 states that have a constitutional right to a healthy environment of this kind. There are a whole boatload of other states that talk about the environment in their constitutions, but they don't rise to the level of what Pennsylvania and Montana have. If they're in the Bill of Rights section of the Constitution, they might talk about things like fishing, hunting, and trapping rights, or the rights to land preservation. But they don't talk about the rights to clean water, clean air, and a healthy environment. Or perhaps they do talk about environmental rights, some of them with very beautiful language. But they often begin or end the sentence or the paragraph with, and that's good public policy, instantly robbing the provision of its strength. Or they say the way you get these rights is that your state passes laws. Well, the problem is, if your state passes sucky laws that allow pollution and degradation that violate your environmental rights, your constitutional right has been vindicated. You got what you were promised, but you're not really better off when it comes to your environmental rights. And most importantly, they don't fulfill all of the elements of what I call a green amendment. They're not in the Bill of Rights section of the Constitution. They are not self-executing, meaning you don't need laws to give it legal life. They don't protect the rights to pure water, clean air, a stable climate, and healthy environments for present and future generations. And they don't protect the rights to a healthy environment fundamentally, legally, constitutionally, in the same way we protect all of those other fundamental rights we hold dear, like the right to free speech and freedom of religion. And of course, we have to recognize that our federal Constitution also doesn't have an environmental rights amendment, a green amendment of any kind. I want you to know that since we've started this Green Amendment movement, since we've been spreading the word that people across our nation don't have environmental rights, but that there are 2 states, Pennsylvania and Montana, that do, and that these rights are powerful and important and can be recognized and protected in the Bill of Rights section of our Constitution, we have inspired other states to try to get their own Green Amendments. We have a Green Amendment proposal that has been put forth in the state of New York, one in the state of New Jersey, one in the state of Maryland, and one in the state of West Virginia. And we have other states across the nation that are looking to follow suit. We're anticipating very soon a Green Amendment in the state of Vermont. Next year, we're hopeful to have one in the state of New Mexico, and there are others that are in the works. Now here in the Commonwealth of Pennsylvania, right, while all those other states are pursuing their Green Amendment, the people of Pennsylvania already have one. So we have an incredible opportunity to use Pennsylvania's Green Amendment to protect our rights to a healthy environment. And I would suggest to you that we also have an obligation to make full use of Pennsylvania's Green Amendment. And why? Why do we have an obligation? We have an obligation because all those states, every other state across the nation where I'm speaking, where I'm trying to convince them to follow this path, they're all looking at Pennsylvania and seeing what is happening here, asking the question of whether or not constitutional protection of environmental rights really makes a difference. I mean, they point out to me all the time, you had a Green Amendment in Pennsylvania for 49 years, and yet you still have pollution and degradation, you still have fracking. So does it really make a difference? solution to many, not all, of the environmental challenges that we face, right? First off, Pennsylvania, like I said, is just now defining what it means to have a constitutional right for a healthy environment. Chief Justice Castile only wrote that first opinion, breathing legal life back into the Environmental Rights Amendment in December of 2013. That's not that long ago when you look at the slow wheels of justice. But we are making a difference. We have a number of cases and decisions that are advancing key environmental protections in the state. And again, I'm not going to overstep on what Professor Dernbach is going to talk about. But more broad brush, rather than talking about specific cases, the implementation of Pennsylvania's Green Amendments is starting to protect environmental rights legally, constitutionally, the same way we protect those other fundamental rights we hold dear. I mean, think about how powerfully, right? Think about how powerfully property rights, speech rights, gun rights are protected here in this nation because they're in the Bill of Rights section of the Constitution. That same power and strength, legal and advocacy, comes to bear on environmental rights. We are starting to get decisions that are protecting the environment, not just for the present generations who are here today, but for the future generations that are yet to come. We are changing the focus of government decision-making from managing and permitting way down at the end of the process to preventing pollution, degradation, and harm at the beginning of the process. Environmental justice is being strengthened because every individual in the state has the same constitutional right to a healthy environment, and they all must be protected equitably, regardless of the color of their skin, their ethnicity, where they live, their income level. We are forcing science and facts and consideration of cumulative impacts back into the decision-making process in the beginning of the process when it can make a difference, not at the end of the process when you're simply trying to explain the good or bad decision that government may have made. And of course, we're spreading the word so that people are taking full advantage in their advocacy, in their lives, talking with their legislators about the fact that the people of Pennsylvania have a constitutional right to pure water, clean air, and a healthy environment. Those are our little Loraxes that spoke to Governor Bill. Sorry, I just can't resist the picture. So, as I said, the fact is, right, Green Amendments really are making a difference here in the Commonwealth of Pennsylvania, in the state of Montana, and they can and will make a difference in other states if we can get them passed. But all those other states, whether there's a Green Amendment proposal now where they're just considering whether or not to do it, whether to activate around the passage of a Green Amendment, all those other states really are looking at the Commonwealth of Pennsylvania and really asking the question, does it make a difference? The nation is watching, and so I think we are duty-bound to show them that having a Green Amendment really does make a difference for present and future generations. And with that, I'm going to pass it on.
My job this afternoon is to talk about how we got to where we are. And what I want to, basically the story is more detailed, and I think in some ways is pretty interesting about how we started out with Article 1, Section 27, what happened to it, it was abandoned, and more recently it was restored. Now, I'm substituting for Franklin Curry. He called me on Monday. He's had a virus for about 2 weeks, like a really pretty serious virus that is compromising a lot of things, and he said, will you fill in for me? And that made sense, not just because I'm the random environmental law professor who's close by, but because I've done a ton of work, literally I think, a ton of work, trying to figure out what Article 1, Section 27 means, interpreting it for the courts, doing my own advocacy, or advocacy out of the Environmental Law and Sustainability Center at Widener, putting together the legislative history of the Environmental Rights Amendment, among many, many other things. And so, in a sense, I'm channeling Franklin Curry this afternoon, but I'm going to do it my own way. All right? So, here's where we are. some of you know this, all right? We had it, some of you know this particular poem. I'm guessing you studied this poet in English Lit at some point or another. The Environmental Rights Amendment was adopted overwhelmingly, as Maya said, by voters of Pennsylvania in May 1971. And so why are we talking about it as if it's a new thing? Well, we're talking about it as if it's a new thing because what the courts did to it effectively was bury it for 40 years. And I'm going to talk about how that happened, because how that happened offers a lot of lessons for how we need to move forward. But where we are right now is nearly 50 years after the Environmental Rights Amendment has been passed. We are looking at the text of it. We are looking at what it means in a more serious way than we have in decades. And so in a fundamental way, we're looking at it as if for the first time. Now, you've seen the text of this, and what I want to show you, I'm going to ask you to sort of walk with me a little bit through this. There are 3 sentences in the amendment. One of the challenges that lawyers and policymakers have had with the amendment is you read the 3 sentences together and it all sounds great and you have no idea what it means. So to parse it out, you actually have to read the sentences and you have to read them somewhat carefully. And what I'm giving you now is actually the way it was intended to read, all right, or intended to be understood. The first sentence stands alone from the second and third sentences. So the amendment actually has 2 parts. The 2 sentences that have gotten the most attention in the 2 recent cases, there was a case, the Robinson Township case that Maya talked about, and then one that was decided a couple of years later, Pennsylvania Environmental Defense Foundation case, are based primarily on the second and third sentences. And I'm not going to read them aloud to you, but as you look at them, understand this. What they do is they create a public trust for a category called public natural resources. And they oblige the Commonwealth to conserve and maintain those for the present, for the benefit of both present and future generations. That's what they do. Those are the 2 sentences that have gotten the most attention from the courts. Then there's another sentence, the first sentence, which is different. It doesn't say anything about public trust. It doesn't say anything about public natural resources. And for that and other reasons, you can say, well, this is understood to have a separate meaning. And the separate meaning is that the people, in the second and third sentences, by the way, impose an affirmative obligation on the Commonwealth, right? The Commonwealth shall conserve and maintain these public natural resources. The first sentence does not impose any affirmative obligation on the Commonwealth. What it says instead is that people have a right to these things, clean air, pure water, and the preservation of certain values in the environment, all right? And that's really all it says. And so you're looking at the first sentence, and you're looking at the second and third sentences, and then you need to understand as a starting point that they were understood from the beginning to mean something different. Each of them was understood to mean something different. So, now I talked to Franklin last night. Franklin tells me last night, there's some things you need to be sure to tell everybody at this presentation today. So here I'm channeling Franklin. Okay? Take a look at the photo for a second. Put that on the cover of his book. All right? That was the one on the right, the jar on the right, is actually river water. All right? The jar on the left, of course, is clean. And he ran as a young lawyer, a recent grad, Penn Law School. He ran for the legislature in 1966. He beat a longtime Republican who voted against clean streams. And his explanation of Section 27 is his idea was that it was intended to make sure that the environment somehow depoliticized the environment by putting it into the Constitution. And here was his idea. He understood in the late 60s, early 1970s, that the environmental movement was peaking. All right, that there would come a time when the environmental movement would not be as popular. Imagine that. Okay? And his idea was that he wanted something in the Constitution, something that would be relatively permanent, something that would be relatively durable, that would protect the environment and sort of protect it against sort of the the downswings in the political cycle. And so in spring of 1969, at the dawn of the modern environmental movement, he stands in front of the legislature and he says, I'm introducing this resolution based on text that was pretty similar to this. Because the people of Pennsylvania deserve to have because the right to a clean environment is just as important as the right to free speech, it's just as important as the right to free assembly, and it's just as important as other rights that we have. Human rights is something very similar to that. From a legal point of view, one of the most important things about this is that it got placed in Article 1 of the Constitution, which contains the Declaration of Rights. This is where all the other rights that Pennsylvanians have. You're familiar with the Federal Bill of Rights, I'm quite sure of that. But there's also a State Bill of Rights and a State Constitution, and the State Constitution that protects those. And the critical point here, all right, is that if that section had been placed almost anywhere else or had been written in some different way, it wouldn't have been nearly as effective or as important as it turns out to be. And Maya's point about this Pennsylvania being unique, I can echo in a different way, is if you don't put it in the Bill of Rights, it's hard to have to call it a right. Okay. So, the very first case, look, Gettysburg Tower. How many of you know about the Gettysburg Tower? Okay. Not as the older people. All right. So here's how it goes. In the early 1970s, the developer of this tower negotiated with the Park Service. They figured out a place to put a tower on private land without any governmental approval, because you didn't need any governmental approval at the time. And the idea was to be an observation tower looking over the whole battlefield. Okay, that was the idea. And it got built. But before it got built, there was the very first lawsuit on Section 27 was a lawsuit by the Attorney General, okay, to try and stop it. Now, the Attorney General says, go back to the first sentence, okay, what the tower is going to do for park visitors is it's going to interfere with their natural, scenic, historic, and aesthetic values of the environment, because people are going to be out there trying to get a sense of what it was like to be on the battlefield in July 1863, and they're going to see the tower and it's just going to mess up their experience. That was the argument. Okay? And it lost. And I could go through chapter and verse why it lost. All right? But what happened is it got appealed to Commonwealth Court, and then it got appealed to the Supreme Court, and the lawsuit created a mess. And the mess that it created was of two kinds. One, the rights that you have in the Bill of Rights are rights that you have as against the government. The government cannot take away your right to free speech. The government cannot take away your right to freedom of religion. That's how it works. But here the government wasn't taking anything away. Instead, the government was using the amendment against a private developer. And a lot of people didn't see the Gettysburg Tower as such a bad thing. How many of you, by the way, those of you, how many worked in the Gettysburg Tower? Anybody go to the Gettysburg Tower? No one said, the students. Okay. Did you go to the Gettysburg Tower? Yeah, what did you think? How was your experience?
It was a neat thing to look at as far as a commercial development. I didn't think too much was necessary on the battlefield.
Okay, all right.
But I'm a visitor, not a visitor of transplant, so.
Yeah, I got it. So it wasn't like, well, I mean, you can stand right at the head of Pickett's Charge and see the KFC across the, it's not like this is, pure and holy and unaffected by modern development. But even the common police court, Judge McPhail, who was here in Adams County, no, I don't think this is a perfect injunction. And so what happened is, it began to get the courts nervous that what Section 27 was really about, okay, was stopping development, period. And then it got worse. Okay? Payne versus Cassatt was a challenge to a street widening project in Wilkes-Barre. All right? It was, I don't know, it's half an acre out of maybe 20-acre park, something like that. The challenge was, wait a minute, you can't take away that half acre of public park because that violates the public trust part of the amendment. Okay, if you go back, again, the public trust part of the amendment is the second and third sentences. And the plaintiff said, no, you can't do that. You can't do that. And Commonwealth Court is looking at this, and this is the dawn of the modern environmental movement. Okay, context for a second. Pretty much all of the statutes that are being administered and enforced in Pennsylvania right now were adopted between about 1969 and about 1980 and after. Okay, the modern environmental movement really began in the late 60s, early 1970s. And before that, and I'm not saying that everything in the modern environmental law is perfect and wonderful, and I'm not necessarily contradicting Maya, but understand this, it's a whole lot different now than it was in the late 60s. It's a whole lot different. And so you have all these laws, and so we're right at the beginning of thinking about, well, how do you do a really serious effort to protect the environment? And the court is looking at this and they're saying, holy smokes, okay, if this environmental rights amendment means that the state can't even widen a street for safety purposes without getting into trouble, then we have to do something about the amendment. And what they did, is they adopted a test that basically took the amendment and turned it into pretty close to nothing. All right? Was there compliance with all applicable law? Well, gosh, you don't need a legal rule to say that you have to comply with the law. Right? That's out there anyway. Did the record demonstrate a reasonable effort to reduce environmental incursion to a minimum? That's always going to be the case. There's always going to be some effort, and whether it's reasonable or not is a question. And then, oh, by the way, do the benefits of the harm of the project outweigh the benefits? Well, people that advocate the project wouldn't go ahead with it unless they thought that the benefits outweigh the harms. And so over and over and over again, stuff on the Environmental Rights Amendment just lost, right? And I did a paper with a student a couple of years ago. He was really good. And he put together this record, okay? And basically, pretty much all the reported cases came out against the Environmental Rights Amendment, anywhere. Now, when this test was the law of Pennsylvania in Section 27, I was a young lawyer, yes, I was young once, at the Department of Environmental Resources in the early 1980s. And I remember that there was a poster of Article 1, Section 27 all over, okay? About 8.5 by 11, like little black frame, glass, all that, with it said our mission over the top, and then you had these three sentences. And I thought, gosh, this is really nice. I wonder what it would mean if the courts treated it like law. And so when I went to the department, when I left the department and went to work at Widener Law School, and right coming up for tenure, I'm looking at, I thought, well, let's figure out what Article 1, Section 27 means. And so I went deep. I looked at the legislative history, I looked at what other states have done, and all the rest. And I put together a two-part article that explained how the courts could use Section 27 and make sense out of it. And people, my friends at the Department of Environmental Resources nodded and said, yep, that'll get you tenure all right, but it won't make any difference. All right? And so I just bookmarked that. Okay? So then the Robinson Township case comes along. And yes, Article 1, Section 27 was brief. But so were a lot of other things. And what happened here, the issue that drove, I think, the court really nuts is governments had the ability to, before Act 13 was passed, to do their own zoning. Okay, so you get to decide, you don't get to decide how shale gas gets regulated, but you do get to decide where it goes. Okay, so you get to decide as a local government, hey, we'll put it in industrial zone, we won't put it in a residential zone. That's it. And Act 13 swept that all away. They created the statewide authority through the Public Utility Commission to come up with different results. And the Commonwealth, and the Supreme Court, Chief Justice Castillo, as you heard, but this is just wrong. Governments, you don't get the right to do this to people. You don't get the right to allow compressor stations and shale gas drilling to occur right next to where people live. You don't get to do that at a state level. That's just wrong. That violates their rights to a clean environment. That's what really, I think, more than anything, tripped the court's trigger. And there's some other stuff, to be very sure. It's a long, complicated opinion. But here's the thing. Only 3 justices out of 7 voted for that. That's a plurality. That doesn't give you a majority. But what the Robinson Township opinion did, and this was so interesting, I'm grading seminar papers in December of 2013, and I'm reading this opinion, I'm seeing my name in the footnotes again and again and again and again. I'm thinking, oh yeah, those two articles that I wrote, 16 years ago, or whatever it was, okay? But that's really, to some degree, that's at least my part of the story. A couple of years later, the Supreme Court took the Robinson Township plurality and turned it into law. There was also a case involving shale gas. And what happens here, if you go back in time, is the state has had this sort of modest, mom and pop kind of leasing operation for oil and gas, but never very consequential. It only brought in a couple $1 million a year on state forests and parks. And it was mostly oil drilling, small wells, no big deal. And then the shale gas revolution happened. All right. And beginning in about 2006, thereafter, when they figured out that you could actually take shale gas and make money out of it, nobody really thought you could do that beforehand. And it just exploded. And the way shale gas works, by the way, traditional well drilling is there's a kind of like a pool underground, and the idea is to go vertically down and find where the pool is. What shale gas is about is you get these big, thick slabs of shale, thousands of feet from top to bottom. And the gas is all through the shale. It's not pooled anywhere. And so in order to get the gas out of the shale, what you need to do is you drill down to the shale layer, then you drill horizontally through the shale, and then you use fluid and explosives and high pressure water to sort of fraction the shale a whole bunch. And then the gas comes out. Okay? And then the gas comes out. So what happened is suddenly there was all this state land that was available to do this, and no one had really thought about that before. And oh, by the way, the economy tanked in 2008. So the state leased a boatload of land, and then changed the legislation that had sent the money from oil and gas leasing right back to the state to fix up state forests and to acquire land and that sort of thing. They took that land and that money and said, no, we're going to use it to balance the budget. Okay? We're going to use it to balance the budget. And in the Pennsylvania Environmental Defense Foundation case, the court said, no, you can't. It says in the Constitution that these resources, these public natural resources, which include state forests and the gas that is located under them, must be used to conserve and maintain public natural resources. Oh, by the way, you have to use the money you get from these resources to conserve and maintain public natural resources. You don't get the ability to take the resources, make a lot of money off them, and then use that money for something else. You can't do that. Okay? So, they took the pain test and they set it aside. And they said instead, the new rule is, hey, follow the Constitution. Now, they're focusing on the public trust, all right, and the public trust derives to some degree from trust law, which is large, and I'm not going to get into it, but but you use trust principles to help you figure out what the text of the Constitution is. Okay? So how does the legal rule work now? Well, what happens is the court says there are 2 sets of rights. Just as I said at the beginning. First sentence, I showed you the first sentence before. What does the court say that means? This places a limit on the state's power to act contrary to the right. Okay, the state cannot interfere with that right. Well, what do the second and third sentences mean? Well, okay, if you read sort of the bottom, they say, well, the people, okay, the named beneficiaries of the trust, and all agencies and entities of the government, both statewide and local, have a constitutional trust responsibility. That includes local governments. When mine is going out and talking to local government, she's doing it in the strength of 23. It's not just the state. At the state level, it's also local governments. And so what are the duties of the trustees? Well, the duties of the trustees, okay, is you got to prohibit the degradation, diminution, and depletion of these resources. And you have to act affirmatively, meaning the Commonwealth has to act affirmatively, okay, to protect the environment. That's what that means. They talk about traditional trust law to be used to determine the meaning of the public trust. I'm not going to get into that too much, except it's a higher level of care. One way of understanding this is as follows, okay? If you put money in a savings account or a checking account, you're counting on the government, on the bank, or the savings and loan, or whoever it is to take care of your money, all right? You're not counting on them to dribble away the assets, to invest it in something else, and to sort of manage the steady degradation of the money that you put in. You're not doing that. That's not what your expectation is. If you make the government the trustee, and the government is the trustee, then the government has the same responsibility for public natural resources as the banker has for your money. Imagine that. That's how this works. Think about that. Okay? And I could go through the duties of loyalty, impartiality, and prudence, but I won't because I don't want to put you asleep and get into trying to trust law. But those are duties that trustees have. All right. So, basically, and I think I've already explained this, the court said, well, look, the royalty money has to be spent to conserve and maintain public natural resources. Okay? It just has to be done that way. And they said also, when we get into, there's one other category of rental and bonuses that that the state also received that aren't quite royalty money. And the question, and that was an open question. The Supreme Court sent that back to Commonwealth Court. And by an open question, I mean, should that be treated the same way as royalties, or should the state be able to spend that any way it wants? Anyway. And so, why does this matter? Well, it matters for a whole bunch of reasons. And I think the big reason it matters is that it puts Section 27 on the radar. I wrote, the two articles that I wrote years ago that had different subtitles because it was a two-part article, but it was treating the Pennsylvania Constitution seriously when it protects the environment. All right, that was the title of those articles. And I said that, and there was an edge in those titles. All right, because the environment, the Pennsylvania Constitution was not being taken seriously when it protected the environment, and now it is. And more accurately, perhaps, it's not protecting the environment, it's protecting you and me, okay, and our kids and our parents. There are some supporting roles that Section 27 has also had over the years that are worth commenting on. I'll just give you a single example. Years ago, the City of Philadelphia enacted a historic preservation ordinance. And a private property owner said, hey, wait a minute, you can't do that. That's taking my property without compensation, and you don't have the legal right to do that. And the Supreme Court said, well, but, you know, look at the first sentence of Section 27. People have a right to, preservation of the historic values of the environment. That gives the City of Philadelphia the authority to protect historic resources. Okay? And those kind of cases don't get as much attention. They're not as exciting because it's not the amendment slamming down on somebody or stopping somebody from doing some bad thing or stopping the legislature from doing something bad. But at the margins, those cases matter a lot. At the margins, cases like that matter a lot. So, boy, is there a lot of litigation going on. I'm not going to summarize it for you. I'm not even going to try. I'm just going to tell you that there's a whole bunch of stuff going on, and we can talk about it in as much detail as you want. But let me just give you some idea of the kinds of issues that are on the table still. All right? And I think I have 4 items on this list. When I gave this presentation at a law school some months ago, and I had 10 items. Okay, and it's not like the other 6 got solved. It's just that I'm thinking that 4 is probably good enough to give you a flavor for this. All right. One is, so how can the royalty and other money be spent? All right, and there's ongoing litigation about this. Here's what basically DCNR and the State Attorney General are saying right now. They're basically saying, well, look, okay, we can't. PEDF, the Pennsylvania Environmental Defense Foundation case says we can't spend the money anywhere in the budget. Okay, so we won't spend the money anywhere in the budget anymore. Here's what we're going to do. We're going to spend it all in DCNR. The all the royalty money is going to come back in the Department of Conservation and Natural Resources. That's how we're going to spend the money. And so the money the general fund money that we used to give to the Department of Conservation and Natural Resources, we won't have to give that to them anymore because, oh well, we'll just give it to somebody else. Okay? So, and John Child, on behalf of the Pennsylvania Environmental Defense Foundation, is saying, well, but wait a minute. If you do that, what you're doing is you're converting public assets, all right, basically into spending money. And it isn't very much different than just using the money to spend anywhere you want in the budget. It's just moving dollars around. And oh, by the way, this is a really big deal. There's a lot of money here. You can see the bottom line here. There's over $1 billion in assets on the table here. This is not a small thing. It's a really big thing. So what about that first sentence? You know, about protecting the right to clean air, pure water, and the preservation of these values of the environment. Well, Gettysburg Tower is still out there, and it still sort of, kind of, with some ambiguity, says that the Attorney General can sue people for violating the amendment. And I have to tell you that the private lawyers that I know who do not like the Environmental Rights Amendment at all, okay, go back to Gettysburg Tower and say, see, that's the terrifying thing that the Environmental Rights Amendment can do. It can empower the government to go after private property owners. Okay? And I think there's an answer to that. I think Gettysburg Tower is probably wrongly decided. I think it would have been easier in the first place instead of denying the injunction to just say, look, we don't use the Environmental Rights Amendment as a source of government authority. They can limit government authority, but we don't use it as a source of government authority. Third thing, what's the best method of implementation? Well, okay, we've all heard about litigation. It has its strengths and its weaknesses. But imagine this. Imagine that the state of Pennsylvania says, oh, we have a right to protect public natural resources. Okay? Maybe we ought to publish on an annual basis what those resources are. Okay? Maybe we ought to, in that report, maybe we ought to tell people how they're doing, what the threats are. And because these are the people's resources, and the people ought to know, and oh, by the way, all right, if you have money invested anywhere, the person who has invested your money has a, you know, the bank or the mutual fund or the company with whom you have stock shares has some obligation to let you know how it's all going. This is standard trust law. Okay? But that's not what's being done right now. The Department of Environmental Protection could say, well, look, we're going to do a review of all our regulations, we're going to look for where the gaps are, and we're going to fill them. Okay, where does Section 27 create, where does Section 27 identify things that need to be done that are not now being done? And this is particularly important because the landscape is so different now than it was in 1971. There weren't that many environmental laws. Now there are a ton of them. Well, okay, one of the questions that people have is, so in what specific ways does the Environmental Rights Amendment fill gaps? Well, I can tell you, based on these two cases, one way they fill gaps is they provide an anti-backsliding rule. All right? The legislature goes back on something that got done before, whether it's zoning or the way that oil and gas lease money used to be spent, and the court can say, no, you can't do that. Okay? You can't do that. But what other rules do they play? The one thing that is quite clear, I think, is that a lot of the litigation that's going on at the hearing board and the county police court level, a lot of developers are fixing the most obvious gross environmental things in their proposals, whether law requires that or not, because they're scared to death of another adverse decision in Section 27. Okay. Now I'll give you one last one because this is provoking perhaps. Is what about climate change? Okay. Because the atmosphere is a public natural resource, so is much of the water. Climate change is going to have really bad impacts on Pennsylvania. They're very well documented. Temperatures in Pennsylvania are probably going to be 5 degrees Fahrenheit higher than they were in 2000 by 2050. Okay? Welcome to the world you're all growing old in. Okay? And I don't say that to make fun of you. It's just this is the world that we're growing into. And what role can Section 27 play in that? Well, one role, Bobby McKinstry is a retired lawyer, I know, and a bunch of us filed a petition for rulemaking to the state about more than a year ago saying, hey, you know what you ought to do is establish a cap and trade program for greenhouse gas emissions. And oh, by the way, we have an obligation under Article 1, Section 27 of the Pennsylvania Constitution to do that. Okay? So, I've got a few copies of a recent article that are here. I appropriated some part of mine, so maybe in front here. I hope there's trouble with that. All right. So if you want sort of the legal side of this, it's I have a pretty detailed description of the most recent case. And if you don't want to take a paper copy with you, pretty much everything that I know of that's been written about Article 1, Section 27 is at this. And if you Google Widener University Commonwealth Law School, the Article 1, Section 27 resources, you'll find it. We've got 2 versions in the legislative history. We've got a ton of articles. There's a bunch of stuff. Okay. And if you need time to meet, here I am.
On the current polyfluorinated alkyl substances, the PFAS forever chemicals, and I know, Maya, I think you all have been working on that. There's several communities in Pennsylvania that have been impacted. How does this apply to those situations where we've got watersheds and community water supplies have been contaminated?
So can I quickly talk about the litigation we have, and then you can fill in? So we actually, Delaware Riverkeeper Network, filed a petition under the law with the Environmental Quality Board a couple of years ago now to say that you have to put in place MCLs, water quality standards, to address the per and polyfluoroalkyl, right? This is, if you've heard of PFAS, PFOS, PFOA, PFNA, these are highly dangerous contaminants that are in drinking water supply because of firefighting foams and industrial uses that were very legal under the law as they happened. And communities across the nation are finding it in their drinking water and in their environments. So here in the Commonwealth of Pennsylvania, where there's no law to address it, no law to force it to come out of the environment, right? We filed this petition a couple of years ago, again, under Pennsylvania law, to say you need to put in place what are called MCLs, drinking water quality standards. We then waited the requisite time period that the law gives government to act. The Environmental Quality Board accepted the petition and said, yes, this is a good thing, and it should move forth. And then the Department of Environmental Protection had a period of time within which it could act to accept and then advance this petition, respond to it. And the Department of Environmental Protection failed to do so. I think they had about a year. It was a couple of years. They hadn't done anything. So we actually have filed a lawsuit citing, in part, Article 1, Section 27, and the duty of the state to take action. As John mentioned, one of the benefits of Article 1, Section 27 is it fills gaps in the law. So per and polyfluoroalkyl chemicals is one of those gaps. We're using Article 1, Section 27 to seek to fill that gap. That case is currently moving forward, but this is a very, very important cornerstone of our legal arguments.
I don't know that I have a lot to add. I mean, what you have to do on that is, there's plainly an obligation of the state. There's plainly a gap here. And the issue is how to use Section 27 towards action. I think, the climate issue is in some respects the same kind of question. Is that we file a petition and we're waiting and we're waiting. I think Section 27 can be used towards action.
And it's one of the reasons why we're encouraging other states, right, that have PFAS, PFOA problems. Because if they were to get this passed, it then becomes a tool in other places as well, for a myriad of things, but that's one of them. Thank you. Do you want to pull over? Oh, do you have a question?
Yes. Go ahead.
Okay, I just want, so there is an individual private right of action under Section 27?
Yeah, you have to demonstrate standing, but
Okay.
yes.
Gotcha.
So, but I do, it's one of the things that's, gets raised in other states, right? In other states, there was, for example, in Maryland, the community specifically wanted to add a private cause of action, one private actor against another private actor. And we actually, based on the Pennsylvania experience and the interpretation and the strength that comes out of the interpretation, as John said, that this is a restraint on government action, right? We actually encourage the legislators in that state, don't try to do that stretch, right? Put it in the Bill of Rights and then use constitutional Bill of Rights language and interpretation to maintain that strength. And so they did actually, the second go around, we did get them the legislators to pull that that out because we do view that as being dangerous to the success of the passage of the amendment, but also, pulling and stretching constitutional law in ways that we think would undermine the entire Green Amendment movement.
If I can just, one thing, and it may come up in questions, but just so I don't forget to say it, is that the Pennsylvania history demonstrates that the judges actually have to believe in this. Okay, it's not enough to have something on the books, the judges actually have to believe in it. And what I mean by that is they have to believe that by applying the amendment, they're doing the right thing and they're not going to shut down the economy and they're not going to screw everything up. And the challenge you have with environmental rights amendments is there aren't that many of them out there. The judicial experience with them is pretty limited. Courts tend to be pretty cautious. And so you create something that looks, if people are still sensitive about this, is we do not want to go back to Payne versus Cassav and Gettysburg Tower again. So picking cases where there are good facts, where you can make good law, is really important slice of reality.